Hello friends, welcome. Friends, morning I wrote an article. So this is an article which I wrote, the Decoding the Duel, Navigating Google App Store Controversy in India's Startup Ecosystem. Now, friends, you might have already seen that we are flooded with all kinds of news in the public domain where it says that Google has pulls popular Indian apps from the store over fee dispute. And then there are other articles which talks about that the minister will not allow the app stores to be the Indian apps to get pulled out of the app store, and they might be having some resolution, and there must be some discussion which is going on with the minister, right? So what I thought is to explain to you the real issue, the constraints that we have, and what party is playing what game, and what kind of leverage and constraint the parties are having. When I say parties, it is actually everybody, including the litigators, the educating agencies like High Court, Supreme Court, the CCI, and the Government of India. So everybody. So we are going to talk about everybody who has what leverage and what is the issue that everybody is facing in this tangle. So what I did is, in the morning, my article is very short, and since this is not covering every aspect of legality, I thought it will be useful for me to do this video to explain to you what this issue is all about in very, very simple terms. I will not go into the details of legality because that is in the lawyer's domain and it will confuse the whole issue. I like to simplify this as much as I can. Anyway, anybody who is reading this article having some context will understand it, but that is the reason I'm doing this video, is that whoever doesn't have the context, for them, the key issues or the key points of arguments I want to highlight so that they can understand the reality of the debate and what are the constraints the parties are dealing with. Now, before I take you through the details of this video or the presentation, I would like to say that I did another article on Google India litigation on 25th July 2023, and this article captured the two CCI judgment. So the CCI judgment which came out consecutively, and I gave the background also, and I have listed out the various orders of CCI and the options that Google had for implementation. So there was one order was of 20th October 2022. And then the other order was on 25th October 2022, and these were all attached with fine. So somebody filed a complaint in CCI, and the CCI investigated and found that the Google is behaving in an anti-competitive manner and disturbing the market, and therefore certain remedies were proposed in order to constrain Google not to abuse its dominance. Now, it was not proven in this, by the way. It is very clear that when I read the order, I could not find any conclusive proof by CCI of Google having exercised and abused its dominance. But what was very clear that the actions that Google was doing could actually have an impact on the negative impact because of the dominant nature of the Google's business. And that's the whole point about this about the CCI order, and the orders were given, and the Google actually had to execute the order. Now it will be very long video if I go through each and every aspect of this order, and anybody who is interested can understand it. Now there is one crucial issue, and the crux of this whole issue is not about the rest of the orders of CCI, except for the fact that one critical issue which concerns every app provider is the app fee structure, which is the percentage in revenue share. Now, unfortunately for the app providers, the CCI did not give any remedy to suggest that what fee structure that Google should charge. They left it as it is. Now, if you read this is right in front of you. The app fee structure, percentage revenue share. Please note that I wrote, please note that the Commission, through investigated this matter, but refrained from passing any remedies and kept the issue open for future deliberation. And you can go through clause 327, page 153 of the CCI order, where you will find that what the CCI has said, based on the foregoing, the commission is of the view the information available on record is not sufficient to give finding on the monetization model as a sketch supra followed by Google, and therefore commission is not inclined to give any finding on this aspect. So it was not given. Now this was the most crucial part which the Indian app providers were looking forward to, but they did not give. Now what is going on is that Google has been able to execute most of the CCI's order. Now there could be debates as to what extent they should have executed, what is that they have not executed. Those are details which I don't want to get into. But they have been able to execute given the fact that CCI is not coming after them. Now if they had blatantly not executed the CCI order, I am quite sure that the Indian government and the Indian CCI, the regulator, has got the power to go after Google and make sure that Google executes, and the Google has executed. Now, after this issue, what has happened is that since the Indian app providers did not get the kind of remedies that they're looking at, and before that, let me give you one point of reference. What Google came out with this new blog post. Sorry, this one. So where is it? So here there was a blog post of I think, yeah. Let me just see. Yeah, I think this is. Yeah, I think this was the blog post. Sorry, this was the blog post. So what they have said is that in response to the recent regulatory development in India, we are not offering all developers the ability to offer an alternative billing system along with Google Play for their mobile and tablet users in India. If the user pays through an alternative billing system, the Google Play service fees will be reduced by 4%. Read the blog post and updated the updated payment policy for more information. So what they've done is that normally what Google actually is doing is, if you look at this particular web page, they have a 3-tier charging system. So just to make it very simple, anybody has got revenues up to $1 million will pay 15% revenue share. Anything beyond that is at 30%. And then there is one subscription model and other transactions. Let's not get into the details. It is very simple. Now what Google has done is that this is what you will pay if you are going through their own app store, which is the Play Store. But let's say if you are going through an alternative billing system, then these are going to get reduced by 4%. Instead of having 15%, it will become 11%. This is basically going to get the 30% will be reduced by 4%. So this is exactly what this particular order talks about. If I go back, and you will find that this rate is reduced by 4%. Now this was a shock to the mobile app providers, because if you go and make payment through an alternate billing system, they will also charge commission, and that commission is around 4%. Now, if Google is going to charge their service fee, and then the other billing system is going to charge commission of 4%, so their benefit is actually netted out. Nothing they get out of this whole tussle which Indian government had with Google based on the complaint. So ultimately, they got nothing, right? And that is where the main contention of this issue is. So what they did was they basically went to High Court. First, and the most important thing is Madras High Court. They went and they filed petition. And in their petition, they basically said to Madras High Court that, look, we are not getting the kind of remedy that we are looking forward to from CCI. And the CCI has been very lenient on Google. And therefore, we are looking forward to you to help us to get the kind of remedy that we need, which is the blatant violation of Google on the CCI's order. Now, I actually have gone through the judgment. Fortunately, unfortunately, whatever you say, I have gone through the judgment. So I'll tell you where the judgment is. Here is the judgment. Now, this is the main judgment which I'm going to show it to you. I have underlined each and every clause here. So, this judgment is actually of 19th January 2024. Now, this was delivered by the Divisional Court of Madras High Court. And in this judgment, what Madras High Court has said in simple terms, it has said that you as a plaintiff is now arguing before us and quoting various other clauses like the PSA Act. Look at this, PSS Act. Sorry, I'm sorry. It is PSS Act. I have written in my article as PSA Act. I'm sorry. I'll correct that. So the PSS Act, and then we are basically talking, and then you are basically also, quoting the Contractual Act of 1872 and seeking remedies on the provision of these acts, right? Saying that whatever Google is doing is in violation of these acts, and these are parallel jurisdiction which are also applicable, in alignment with what the CCI's jurisdiction is all about. And therefore, we are seeking remedies on, we are asking and requesting the divisional bench and the Madras High Court to pass an injunction against Google and prevent Google to execute their illegal, so-called illegal billing system. This should stop, right? If I look at the prayer is actually in the beginning of this order itself. Prayer says appeal under section 13 of the Commercial Code Act of 2015, order 43 rule 1 code of civil procedure with respect to order so and so, and it basically says to set aside the decree of the judgment of 3/8/2023 number so. It's very complicated for anybody to understand. So let me explain what it basically means. See, this order basically this petition went to a single judge. And the single judge of Madras High Court said that, look, you petitioner cannot come to us for any remedy because the CCI Act prevents you to do that. And let me give you the CCI Act. So if you look at that, this is the CCI Act here, and this is the RSS Act, right? No, sorry, this is the CCI Act, and this is the RSS Act, RSS Act. Now, it says, clause 61 of the CCI Act says that no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the commission or the appellate tribunal is empowered by or under this act to determine, and no injunction shall be granted by any court other than the authority in respect of action to be taken in the pursuance of the power conferred under this act. So, the single judge says that, look, I can't do anything. This is what the provision is there. So you better go to CCI. And that is the reason why this is where the problem came, right? So if you look at the, where is my, just a minute, here it is. So here it basically says that they are seeking a remedy on this order, right? And then they have other issues they have it attached with that, and they're saying that injunction is required and you should allow this petition without going through that and make that cause the clause 61 of the CCI Act, which prevents us to basically seek a remedy in the civil jurisdiction, should not be considered, and we should be allowed to argue our case before you lordship. Right, so that's what is the main point of contention was. Now the divisional court went through the argument point by point and said that no, you guys, if you have an issue, please go back to CCI and get remedy directly from CCI. Unless you have exhausted all the options that you have before CCI, we are not going to entertain it. Now let me tell you what my problem was. That, see, look. If you look at my article, this article which I wrote, here is the article. I have made a very simple point. I have basically said that the key issue of the application provider was Google not addressing the revenue share number and reducing to a value which is lower than what they're charging. That was the main point. Other point of compliances were there. You could have argued that either ways, and there could be some ambiguity that this is how it should have been implemented, this is how it should not have been implemented. But anyway, that could have been settled. But the main point of contention is about revenue share. Now, my issue is that if you are going to a divisional court or any court and filing a writ petition against CCI not executing its own order, but here the problem is that the CCI has never passed the order of reduction of revenue share. So if CCI has not passed an order in the first place itself on the reduction of revenue share from 30% or 15% to a number which is lower, then on what basis you are able to argue before the divisional court of the Madras High Court that you are aggrieved by CCI that because CCI is not executing his order, because you have not spelled out anything other than saying that CCI has violated his own terms and conditions. Because if you look at the judgment, here they basically have listed down all the prayers and the arguments which the plaintiff has made. I do not find anywhere, clause by clause, the plaintiff has gone and explained to the divisional high court that why CCI has not acted as per their initial order which were passed in 2022 and they are in violation of their own order. So you have to explain in clear terms, this is the order and this is what they have done and therefore we believe that there is a violation. And the explanation has to be given in clear terms in a very specific way rather than in a vague way. And you should not be bringing out other laws, which is the PSS Act of RBI, the Payment Settlement Act, and the Contractual Act. Those are secondary issues. Those are sectoral issues to be dealt by sectoral regulators who actually have jurisdiction and expertise. Like RBI has the expertise of dealing with, and there also a similar provision exists. That if there is a matter which is under the jurisdiction of RBI and RBI is the regulator with the expertise of dealing with the matter, you can't basically, once the RBI is dealing with a particular matter, without going and approaching to RBI to get remedies from the sectoral regulator who is an expert regulator, you can't be jumping and going to High Court and seek a remedy from there. Because it does not make any sense, because High Court will only come into picture when you have exhausted the RBI's jurisdiction, right? So none of that happened, because you never went to RBI and basically complained to RBI that look, these are the things which are being in violation, which Google is doing, which is against your Payment and Settlement Act, which you have passed in 2007. So given the situation, how can you jump the gun and go to Madras High Court? So you went to Madras High Court. So Madras High Court sent you back to CCI. Ordinarily, what would have happened is that even if you had wanted to argue the case of higher percentage revenue share before the divisional bench of Madras High Court, you should have stated very clearly what harm that your business is encountering in India because of the higher revenue share charges that Google is implementing. If you do not explain in clear terms that look, these are the business harm that I am having. On the contrary, Indian app ecosystem is growing leaps and bounds. If you look at my article, I have mentioned in this here. If you look at this chart in this article, you'll find that this is another link which I have given here, where it's saying that the revenues of Indian app ecosystem is growing leaps and bounds every year. So on what pretext you will argue before the court that I am being harmed because of higher revenue share being charged by Google? So it does not make, you have to make an argument which makes sense, right? And the court can act on that logic. If you make a vague argument without giving any reference documents and support that with financial economic analysis, the court, it is none of that exists in the court judgment, because they might have submitted separately, I don't know. But I am going through the court judgment where Both the plaintiff and the defendant arguments are clearly captured and listed out in the High Court 100-page order, where I don't find any of these things have been argued. Now, since these are not being argued and therefore you are not expected to get any remedy. Now, if you go to Supreme Court with the same argument, do you think that the Supreme Court is going to give any remedy? It is not going to give any remedy because they simply can't. They are not an expert regulator. The jurisdiction still lies with CCI. Now let me tell you what is the problem that CCI is going to have and why CCI cannot execute their wishes of reduction of license fees or the service fees, so-called service fees, from an amount which is currently existing to a lower number. The reason is as simple as what I have explained to you. Unless there is a harm on the market, the growth of the app sector, if the Indian app sector economy, what basis the CCI is going to decide that, this should be the number as far as the payment is concerned, the percentage share has to be this much. They can't. Another problem is that this is a global nature of contract. Every jurisdiction, Google has a similar percentage revenue share. There could be somehow here and there, slight changes, etc. But in general, it is same across the world. Now, on what basis India's regulator is going to jump the gun and basically say, no, Google, in India you should basically give 5% revenue share and charge only 5% revenue share from that when there is no harm. Then on top of it, there is one more issue. CCI is also already investigating Apple. And in India, Apple may not be a competitor to Google because the ecosystem of Apple, as far as the device is concerned, is much lower than the Android ecosystem. Therefore, distribution of Apple apps in India is much lower. And Android is much larger, and therefore Android is a much greater market as far as India is concerned, but not in US, not in any other market. So if in India, CCI jumps and reduces the revenue share as far as the Indian app developers are concerned, this will have a spillover impact globally, where Google is competing with iOS ecosystem where the revenue share percentage are similar in nature what Google is charging. So if Google charges lower in India, what makes you think that it can charge higher number in any of the rest of the geography, right? And that too, it has not been proven anywhere in the world that because of the Google's higher percentage revenue share, the overall app ecosystem, the global app economy is suffering, right? So these are the problems, in the practical problems you need to understand, why CCI cannot act. It's not that CCI doesn't have the power to act. They simply cannot unless there is a viable, the argument supported with facts and figures to prove that there is a harm which is happening in the competitive dynamics of the market, and therefore the system is collapsing, the market is collapsing, which is not the case. Given this context, do you think that any remedy is going to come from Supreme Court or from CCI as far as the revenue share is concerned? It is not. I don't think it is going to happen because of whatever I've explained to you. And when an Apple investigation on similar line in 2021 is already in before CCI, where CCI has to come out with a similar order which CCI came out with for Google. Now, having said that, have we lost everything? Do Indian app providers doesn't have any kind of leverage? That's where the government has to play a very important role. Why? Because fortunately, the CCI order has been able to thrust upon an alternate app store to be sideloaded in Android ecosystem. So Google need to support a sideload. Google actually used to support a sideloading of apps, but you could have a parallel app store loaded into the mobile phone on which already Play Store app store is already there. Now, on the model of ONDC, if the government of India can nurture an app Play Store, Indian app Play Store on the Android ecosystem and provide an alternative to the Indian startups to get hosted in both depending upon their choice, they can be hosted in the government app store or the Google app store on the same device. That will give some leverage to the Indian app providers, and they could then have a better negotiating deal with Google. Otherwise, I don't see that this problem is going to get resolved in any way, because they simply cannot. There is no legal way to resolve this problem. No courts are going to intervene to set any charges or any rate. You can keep on, arguing about and crying about Lagan tax and give whatever name that you want to give about this. It is not going to get, you're not going to get any remedy from court of law, because court needs facts and figures and economic arguments to make judgment. You cannot simply make judgment, out of thin air, right? Just because of emotions. It cannot happen like that. So I think probably you have understood, where I'm coming from. And that is the reason I wrote this article. And you should read this article, and you should read the other article. You will understand it better where we are. And Indian app ecosystem is very important. Indian startups are very important. And by the way, one more fact which I forgot to tell. In China, if you go through my earlier article, you will see in China, there are 7 or 8 apps ecosystem. And there was an article which I have quoted here where Bloomberg, there is a guy who actually wrote this. And if you go and click in this link, you will notice it says that the Chinese app players are charging huge amount of money, right? Even though, they see, this guy saying that the words App Store appeared 340 times in US Congress. The report came out on Tuesday citing complaints about the Epic Games which have been lobbying Apple and Google scale back to 30% cut. Paper also laid the proposal of the company monopoly over distribution. But in China, a 30% cap of app sales sound, just a minute, what happened? Sound pretty good, while app makers of the world have been deriding Apple and Google's share as unfair and unwanted tax. Chinese Android app store frequently cuts about 50%, though there are multiple app stores in China. Now we are basically trying to reduce our fees from 15% to 5%, and China is happy paying 50% of their revenue share to the app store. So read this article. You cannot be making argument in thin air and make emotional argument. Let's be practical about what we want. Let's look at our leverage. We should be, see, it is India's startup ecosystem, they should thrive. But if you make arguments which do not have legs, which are not supported by facts and figures, you will be enriching the lawyers. That's all. They will continue to fight your case, get the money and enrich at your own cost, and ultimately you are not going to get anything out of this whole discourse. That's my main point. So let's understand where we are as far as the situation is concerned, and that's why I thought of doing a little bit more deeper dive video on this particular subject, so as to make people understand that this is not a legal issue. See, legal, you can quote any terms and any contractual clause and you can confuse the hell out of it. Let's understand the principle and the steps, the logical steps that are required for the jurisdiction to take action. They need real data. It is not magic that these entities can do without supporting arguments. Real economic arguments are required for them to act. So, and then there has to be certain other issues like Apple case, which is extremely important. Apple is also charging similar rate, and if Apple is allowed to keep charging 50%, 30% and 15%, and Google is pushed down to 5%, it is going to disturb the level playing condition as far as both the ecosystems are concerned, right? So thank you for your time. I hope that you have understood, and I'll come back to you with a new video next time. Thank you very much.